Hello, and thank you for joining us on today's Ask Andrew show, Canada's first Facebook live streaming family law question and answer show. My name is Andrew Feldstein. I'm the principal and founder of the GTA family law firm, Feldstein Family Law Group. We have offices in Markham, Vaughan, Mississauga, and Oakville in order to assist your needs in family law. Today, I'm joined by special guest, Jared Norton. Jared, welcome to the show.
Thank you. Happy to be here.
Now, today we're going to talk about parenting coordination, and you're a parenting coordinator. Tell me a little bit about what you did to become a parenting coordinator.
Well, my background is primarily in social work. I've been a family mediator for a long time, assessor, and pretty much everything to do with divorce, separation, and high conflict family situations. And parenting coordination was sort of the natural evolution of that. And getting into that area of conflict dispute resolution, supporting families post award, post order. It was just something I was interested in, and sort of as I said, the natural evolution of my background.
Now, I'm assuming our viewers probably have an idea what parenting coordination is, but I'm going to ask you if you can explain it to them because maybe it's something they've heard going through their case or they're watching for a relative and don't really understand it. So
Yeah.
you can explain it.
Sure. Parent coordination, in brief, really is a child-focused ADR process where a professional like myself, typically either a lawyer or social worker, but sometimes psychologist, but under the banner of parent coordination, takes on this sort of hybrid legal mental health role where there's a lot of different sort of functions. And it's, we do parent coaching, co-parent coaching, some parent education, conflict assessment, case management, dispute resolution, sort of on an ongoing basis. And there's this inbuilt mediation arbitration type component where we try to resolve issues on the fly. And if not, we have some determination authority to make some binding decisions for parents.
Okay, so there's a lot to unbundle in that. So I'm going to start with number one. Your background, you have a master of social work.
That's right.
Because one of the concerns I often say to my clients when they come to me and they want to hire a parenting coordinator is what are the credentials? Because there are people out there who will say, I'm a parenting coordinator, have taken the arbitration course so that they can be qualified to do an arbitration, but they don't have that underlying experience of a lawyer or a social worker.
Yeah.
So I want our viewers to be aware that you do have what I would view as the appropriate credentials for that. But then we talked about what is a parenting coordinator and what they do. And is that something, if somebody comes to you and says, I recently separated, I need help creating a parenting schedule, is that part of being a parenting coordinator?
Typically, no. I think in this jurisdiction, there's a lot of confusion over what PCs do and do not. And I think a lot of people end up being sort of funneled into parenting coordination, and some PCs who may not, well, I should say this gently, but may not have the background or the training or really fully understand what their role is. They may assist parents in doing that, but PC should not be constructing the parenting time schedule or really developing the parenting plan. That should happen before, well in advance of PC. PC is really the dispute resolution mechanism embedded into that agreement. So it's a long way of saying no, they should be dealing with that before they even get to PC.
So, as an example, a family could come to you and they could say, we'd like to hire you to help mediate our resolution to formulate a parenting schedule. And that would be you wearing a different hat. That would be you wearing a hat as a mediator. And then whether it's you or somebody else after the resolution has been arrived at would be there to assist in the implementation and interpretation of the existing parenting schedule.
That's right. That's right. And so often I do that. I mean, if you look at the sort of the best practice models and the sort of the practice guidelines, typically we don't take on the dual sequential role. So I wouldn't step from mediator and then into the parenting coordination role. And there's a number of sort of reasons why it's suggested we don't do that. Some mediators will, but I'll often mediate and then help people understand what parenting coordination is. And then they go off and find a separate PC, or vice versa. People will mediate and then I'll sort of take on the PC role.
Okay. And I think that's a really important distinction because I can't say how many times I've had an argument with a lawyer who says, well, let's just send them off to parenting coordinator in order to develop a parenting schedule. And I'm like, well, wait a second. that's not what the parenting coordinator is for, because they're just, as you said, it's implementation and interpretation. Now, are there any limits to being a parenting coordinator?
Well, I mean, there's limits in terms of what we can and cannot address. I mean, we PCs typically should not be dealing with issues of mobility. They don't do anything like, create major changes to the parenting schedule that could impact the quantum of child support. We're not there to change the decision-making protocols. Again, it's a type of secondary arbitration. We deal with minor issues that are based on pre-existing agreements. So we do have some limitations, and really, PCs, even though we have some decision-making authority, don't have a tremendous amount of power. And this is perhaps one of the things that prospective clients and counsel need to understand. We really can't manage and deal with really ongoing bad behavior and non-compliance issues. I mean, it's just very, very difficult to do in process. So we certainly have limitations.
I understand you have limitations, and it's interesting. You feel as a parenting coordinator, you don't have much power. But to the parties that are involved in the dispute, it's unfortunate when people are separated, a lot of their fight is about power and control. Yeah. And that could be about, I need an extra day because my brother's getting married, and one person wants to say no to it. It could be a parent has passed away and somebody is saying you shouldn't take your children to the funeral. And you could be called in to make that kind of decision. So whereas in the whole scheme of things, to professionals who do this every day, those decisions probably seem rather obvious, but to the parties involved who are fighting about power and control, it really is critically important to them.
That's right, and that's a great observation. I mean, that's the thing. When I say it's not a lot of power, it is through the lens of a PC understanding process globally. But these are deeply personal, sort of often day-to-day issues. And because we deal with them all the time, they probably do, from a professional standpoint, take on a little bit less significance in our minds. But they're very personal, they're very important for the families. They carry no less weight. So in that respect, we do have power, and people do push back, and that creates a lot of tension in process because, who gets to go on the field trip can be, a major decision in some people's minds. But to us, it's as simple as let's just get it done and move forward.
And you've talked about a couple of things. You mentioned the term med-arb, you mentioned secondary arbitration. For our viewers, can you explain what med-arb is, and then explain what a secondary arbitration is that's different than a regular arbitration?
Sure. So the med-arb component is different in PC than, say, a traditional mediation arbitration where you go through the mediation process and then that person transitions into doing the arbitration. It takes a similar feel, but it really is, in parenting coordination, it's sort of, often mediate by email, phone calls, do a little bit of dispute resolution. And then from the arbitration side, we then just get often very brief submissions, on the fly, written brief submissions, and then make a determination. So it's sort of embedded in that process. It usually follows all that parent education and the back and forth. They're sort of trying to finesse these little issues to resolution. Why it's secondary is they have this pre-existing agreement. So often when we arbitrate, we're basing it on what has already been determined. For example, disputes around holiday clauses or interpretation about issues. So we have a template by which we are using to inform often the outcomes of arbitrations. And many times in parenting coordination, we see sort of how the pieces fit together, but there's gaps in the plan. And so we're filling them, we're making determinations based on things that have already, in some respects, have an outcome in the past.
The other piece that is important to me as a lawyer is when something is an arbitration, that creates a process of how an arbitration has to be done. And if it's a first arbitration, it means that there's going to be sworn evidence. It means there's going to be cross-examination. There may be a reporter there to record everything each person says. The arbitrator's going to hear all this evidence, and they may write reasons that could be 50, 100 pages. And the arbitration typically will resemble that of a trial with a judge, except you picked a judge who is not a judge, but a lawyer that has a lot of experience, because that's why you're hiring them, typically. Whereas a secondary arbitration is defined by statute And that's what allows somebody like Jared to do this on a more informal basis that can be done on a summary basis that doesn't require those formalities. And the reason for that to me is really simple. It goes to cost. If you have to pay a lawyer like me to do a arbitration with full evidence, with cross-examinations, with submissions, that's very, very expensive.
Yeah,
Whereas you're having phone calls and emails, it costs some money, but it's not nearly as expensive. And I think the most important point is it's far cheaper than going to court for these issues.
absolutely. I mean, that's really what the process was intended for, is to keep people out of court, to manage sort of, again, what would be considered smaller issues without them having to go back to court, and do it in a cost-effective manner. I mean, it's typical, for example, to have an issue around a transition time, where they, within the provision of their agreement, there's something like the parents have to negotiate the time 30 days in advance. Well, sometimes they can't do that. So if they can't figure that out, it's much easier to just present me with some brief submissions. I then review it and can make a determination, rather than all the cost of going through counsel and court and all of that for really what should be a quick determination.
It's interesting you say that, because what I'll never forget is I was against another senior lawyer that I've known a long time. And we were in court at a conference, and we ended up spending all day at the conference. And it was all about the summer schedule. In the first hour, we agreed, shockingly, that it would be week on, week off for the entire summer. But what we couldn't agree on was the transition time for special things that took place on 3 or 4 weeks during the course of that summer. Mm. And it was 7 hours of going back and forth of two lawyers who had over 25 years experience. Just for our viewers, think about the burn rate of money on that kind of issues in court and how horrific it was. And both of us were trying to say to our clients, let's get to a deal. Let's get this done. Let's move on. And we couldn't get there. We needed the judge's help. But that was a 7-hour day. And that's a great illustration, a great example of where a parenting coordinator would be much better. And it could be for right or for wrong. Even if you get it wrong on that 2 hours, I still think the family is far better off having you make that decision and not spending what the family spent on myself and the other lawyer fighting about that particular issue. Yeah. And you touched on something else, because you touched on vacations, and we're sitting here and we're doing this show on November 28th. I usually don't mention the date during the show, but I am today. And that means, in my mind, and probably in your mind, we know this means winter vacation, Christmas vacation is coming up for families. And that means for a lot of people, there's fighting that's going to take place. There's disputes that are going to take place about if the agreement isn't clearly identifying who gets Christmas. Maybe somebody wants to take a vacation with the children and they can save $3,000 by leaving Friday instead of Saturday, and they need somebody to go along with changing a date to save a whole lot of money on the trip, or they're trying to mirror it up with somebody else. There's a lot of things that go on in trying to plan this trip when two people are high conflict. And how often do you get involved with that type of work?
All the time. The reality is even when you have very clear holiday provisions within an agreement or an order, the ability for that to somehow translate into the real world living of families is remarkably difficult. The real world doesn't go along with strict transitions often, so we often have to deal with that. The other complexity is that when you look at a lot of parenting plans and parenting provisions, there's a lot of ambiguity. There's gaps in that. There are areas that set people up for conflict and failure, like putting in you have to negotiate 30 days in advance type provision when there's no history of them being able to do it. So that's going to come across your desk. So it's almost every file. For some reason, there are tensions around holidays and transitions, and grandparents coming into town on the wrong day, and can these parents negotiate? So it's every file.
And it's a fascinating thing, because this goes back to what we said at the beginning. When you have, like you said, grandparents coming in from out of town, that becomes really important to the person to be able to have their children see their parents. They're thinking in their minds, this might be the last Christmas they have together. So there can be a lot of challenges in that. And one of the things as a lawyer, I try to say to people, you might think you're getting along today. It doesn't mean you're getting along tomorrow. So better to have some rules within the agreement that you can rely on. And if the two of you want to cordially alter those rules because it works for you and you get along well enough, all the power to you. But when you say we're just going to divide the holidays equally, what that can easily lead to is bedlam. And I don't know if you see that often, and that probably gives you a tougher challenge to deal with.
It does. I mean, you can, when you look at a lot of parenting plans, you can tell if they were negotiated in a space of workability. Like they were getting along in the moment and they decide, okay, well, we can do this in the future. We can be a bit flexible. But I think to your point, it's better to have that structure in place in the eventuality that you need it, rather than just rely on best hope for outcome, because there will be a time, whether it's with the introduction of a new partner or some other life stressor, where they're just unable to make it work. And not having those provisions, they're setting themselves up for future conflict.
One of the other things I constantly try to say to my clients, and I partly learned this by experiencing my own divorce. So when I split up, my children were 9 and 7. And it's funny, I'd been doing this for a long time, and yet I made the same mistake. As a parent, you think of the agreement almost as if your children, in my case, would always be 9 and 7. And you don't think about the fact that the children are actually growing up during the course of the agreement. And an easy one that I often think about is Mother's Day and Father's Day. So we as parents, when you have younger kids, we put in that a transition will happen, say, at 8 or 9 a.m. on Mother's Day and Father's Day if the children aren't with that parent, because we're thinking that our young kids are always up at 7 in the morning on Sunday mornings. They never sleep in. But then what happens is you get someone who says the agreement says the exchange is to take place Sunday at 8 a.m., and they're really making their 15-year-old and 16-year-old really happy on Sunday morning when they're telling them to get up. And to me, that's always been a real good example that I give to my clients, that you need to appreciate. Same thing with Christmas morning and Christmas Day and what times you're doing the exchanges at, that kids who are young will be up early. When they become teenagers, they're not going to be. And you may want to have something that transitions to take that into account in the agreement. And I don't know if people are running to you saying, well, the agreement says 8 in the morning.
They do. I mean, I think, to your point, parenting plans evolve in time, given the changes to not just life circumstances, but the needs of the kids and their ages and stages of development. And so what you negotiate and what you have in place when the kids are young is not generally going to apply when they're teenagers and totally different lived realities. So parents do sometimes are in that space where they have to come back. They may need to tweak things. They may need to change things. They may need to, have that conversation about this no longer works for us. What do we do? And there are, mechanisms within process for us to deal with some of that. And again, it keeps them from having to go back to a more expensive process or time-consuming process. Generally, we can deal with those things relatively quickly.
Now, I often will say to clients, when both sides want a parenting coordinator, I look at that as a great sign. Because even if they don't agree, it means what they do agree upon is that they both want a cost-effective process, and they want decisions to be made that at least limit the conflict. Because if I'm coming to you and you, as you said, you try to mediate it first, you try to work on their skills as a parent. So what you're doing is you're trying to diffuse the situation and you're trying to educate them so hopefully they don't need you again.
Right.
And there's a lot of positives in that. And I tell my clients, when you're doing this, it's a lot better when you want to go on that 1-day early vacation to save, say, $4,000. It's an option that you can do when you have a parenting coordinator. But if you don't have a parenting coordinator, it's not even an option if the other side says no, because it's going to cost more for the lawyer to run to court. And in fact, the judge would look at me and say, Mr. Feldstein, are you really here over $4,000? Aren't you charging your client more than that for this motion today, or at least the same? And the answer is going to be yes. And I gave that illustration to you because my view has always been, if I'm a parent, I don't understand, generally speaking, why people don't want a parenting coordinator. The only reason they don't want a parenting coordinator is typically, in my view, I'd like you to comment on it, is that they want to be able to have delay. They want to be able to have the chaos. They want to be able to say no.
Yeah, it's interesting. I mean, in some of the parents I've talked to who have been very opposed to putting PC in as their dispute resolution mechanism, I think most of the feedback is, as a parent, I'm just reluctant to give someone the keys to the car, right? Like they don't want to turn over the authority. But at the same time, if they understand process and they understand what it can potentially provide them, they often come around to sort of seeing it. I do think that, to your point, there are people who thrive on chaos. There are certainly power and control dynamics that parents and high conflict parents present with where, for whatever reason, they're enmeshed, they're embedded in that conflict, they don't want to let it go. There are certainly, even PC, there's a lot of abuses of power. We constantly have to manage and screen in the PC process to make sure it's suitable, because there are ways that parents can manipulate that process too to keep conflict going or keep bringing things to the table, which does, even in a PC cost-effective process, ramp up cost. So yeah, a lot
Well,
to consider.
well, it's interesting because my view is a person. Sometimes people who have an agreement that sets certain things out, they appreciate that if there is no PC, they can say no. And what I mean by that is, if my brother tells me they're getting married and my brother picks a date for the wedding, and the wedding happens to be on my ex's weekend with the kids, I'm I'm clearly going to win with the PC, and the PC is going to say, of course, the children should be at their uncle's wedding. I think that's
Mhm.
going to happen just about every time. It's more a question of what's the timing that the children should be there, how long should they be there, when should they leave, in terms of photos, and how long the whole function carries on for. And there's some mechanics with that, or swapping the weekend. But the person who wants to just say no can say no, and now forces the other person to potentially spend a whole bucket load of money on going to court to get their kids to show up at their sibling's wedding. And that's only if there's enough time to do it, because there may not be if somebody's doing it quickly. So that's where I say it favors the person who wants the chaos, because it's very easy to say no, take me to court, because then you're only taking somebody to court over something that's significant enough that you're willing to spend the money on.
Yeah. Yeah, and certainly in PC again, the goal is to deal with things quickly. So if the temptation is to delay, and to sort of drag things on, it's not to your advantage to go into PC, because typically, we get notified and we're trying to deal with it by email and phone calls within 24 hours. And then if push comes to shove and we need a resolution, then we can move as quickly as we need to. So it is a lot faster.
And the message I try to say to my clients when this is a discussion is, if you're thinking delay is good and it favors you, you also don't know when it's going to hurt you. You don't know when you're the one who's going to want something, because when each side wants those extra vacation days or an extra bit of time because somebody's in from out of town or swapping things, there's usually a clause in the agreement that allows for these kind of things to take place, providing people are being reasonable, that you get to interpret. And if we don't have a PC, the other side again says no. Then the side who says no will one day ask, and the other person's going to say no because, well, you said no. And that goes to part of the places where the education is.
Right.
And the ultimate thing I also will say to my clients, and I want them to understand, is that even if they have, over a course of a few years, a few skirmishes, and you've taught them how to be better parents in terms of co-parenting, one day when the children graduate from high school, graduate from university, get married, they have children, all of those events are things that parents are going to have to share with one another. And if you've learned to manage your co-parenting better, when you go to those milestone events for your children, you're going to be much happier, because you're not going to be as stressed about seeing your ex and maybe their new partner. But even more important than that, your child's stress level is probably going to be far lower because, I mean, as a mental health professional, how often do children who are going through those milestone events, instead of being excited, are worried about managing their two adult parents' conflict?
Yeah, and I mean, really, everything you're highlighting there goes to that parent education piece, the insight building piece, which is, from my perspective, should be central to the PC process. Often that gets overlooked because it also requires a lot of motivation on the part of the parents to go through that and think about it and make those changes. But there's constantly a push, I think, at least from me as a PC, to rethink problems, to rethink conflict, to, in essence, say yes more and let go of the old dynamics and the old issues and to battle less and to get stuff off the table quickly, because it just frees up your ability as a parent to be a more effective parent, to engage with your child, to have less stress. And so a lot of it is that coaching on how to let go of this old dynamic.
And I think a big part of the dynamic is power and control. It may go back to what was taking place during the marriage to after the marriage. I mean, if I take a traditional marriage, and lots of marriages are not traditional anymore, but in a traditional marriage, you had one spouse was the earner, the other spouse was the primary caregiver. And when the spouse who's the primary caregiver now gets a whole lot of support from the earner resents it and feels, well, I'm also an equal parent and wants to take some power with respect to the children back that they had given up during the course of the marriage. And that other person doesn't like it. And there's a real dynamic of power and control that takes place. And sometimes it's not about, I want that extra 3 hours, as much as I'm going to force you to give me that extra 3 hours. And I think a big part of your job is trying to teach both sides to learn how to deal with those kind of issues in a healthier way. Would that be fair?
Absolutely. It's developing problem solving skills. It's building insight. It's understanding that, the issue on the table is not actually what's often driving it. And that, if you push that stuff aside and focus on just the task of co-parenting, they can move through some of these issues a little bit more easily, and just deal with them as they arise rather than getting trapped by all that baggage.
And it's really sad when you think about people, as you say, who are trapped in the baggage, because the one common denominator, I'm not going to say it's always the case, but just about always, both parents love their children. They both want what's best for their children. They both feel they're doing what's best for the children. But the problem that they get, I guess the logjam happens in their mind, is about all the times that they have that sense and that feeling that they've been wronged by the other spouse. And they have to establish, in essence, a statement of, you're not going to control me anymore, in order to stop that control from continuing. And that's always, I think, one of the hardest parts of the dynamic that you have in your role as a parenting coordinator, is understanding that dynamic within that family, how they're dealing with it, and how you move forward to try and heal that family.
Yeah, I mean, it is very tough, because that stuff flares up almost every time an issue arises, and it really doesn't matter what the issue is. To your point, all that stuff comes flooding back, and so we often have to sort of get in there, manage that, calm that side of it, in order for that sort of left brain problem solving sort of stuff to come out, so that they can now re-engage their co-parent and work through things. So it is often one of the most challenging things, is to wade through that sort of intrapsychic sort of stuff, that tension, just to get to the sort of the real work, which is, let's just deal with the issue, which is, let's figure out the transition time.
That makes a lot of sense. Jared, I wanted to thank you for coming today. We're out of time. I hope our viewers have got an idea on what parenting coordinators do and what they can assist in family law matters. Thank you for joining us, Jared. If you're looking for assistance as part of your separation or divorce matter, feel free to contact us or take a look at our website, separation.ca. The next Ask Andrew show, and it'll be the last one for 2023, is on Tuesday, December 12th at 12 p.m. And if you have any requests or ideas for future shows, please email us at info@feldsteinfamilylaw.com. And thank you for watching.